Again, good morning. For those that have just joined, we'll get started here probably in less than a minute. But if you do wish to change your name, if you hold your mouse over the three little dots on your picture, you can click the three dots and then it'll give you the option to edit your name. And with that, is Kathy? Oh, there she is. All right, perfect. Well, it's right at noon. So I will go ahead and kick us off. Again, good morning. Thanks for joining, everyone. My name is Elizabeth Parks. I work with State Director Andy Markowski, and I'm the Senior Grassroots Manager for NFIB in Connecticut. I'm responsible for grassroots advocacy and engagement, AKA also known as the woman behind the emails, the invites, and the reminders. So thanks again for joining us today. In 2019, Connecticut passed the most generous paid family leave law in the US. Many of you on this call today actually took action to voice concerns about the impact that it would have on small business. And I just wanted to say thank you for engaging. Of course, flash forward to today and the law is in effect, and many small business owners have questions. Knowing that, our NFIB team reached out to the Connecticut Paid Leave Office, who is joining us here today. This opportunity, some housekeeping, this opportunity is meant to be conversational. So please comment and ask questions throughout using the Q&A feature that's towards the bottom of your screen. Questions will be answered as they come through, but it is preferred that if you have questions, you want to go off of mute, we hold those questions to the end of the presentation. And so with that, thank you again for joining today. And I'm going to pass it over to the Connecticut Paid Leave team. Leading the conversation, we have Kathy Mahalik. And of course, I asked for the pronunciation, but I might have just said it wrong because I got nervous. So apologies. The benefits process lead, and of course, Jessica Vargas, the Chief Marketing and Communications Officer. So again, thank you all for being here, and I'll pass it over to you, ladies.
Thank you.
Great. Thanks, Elizabeth. Thank you so much for inviting us to do this. We are really pleased to be here. So Kathy and I have a presentation that we'll run through that will give you what we consider to be the most important information to know about Connecticut paid leave. But as Elizabeth said, please do use the Q&A feature. When I'm talking, Kathy will try to answer questions and vice versa. And then, of course, we'll open it up at the end for any additional questions that we did not get to address. So, all right, let me share and we'll get started. Okay. All right, so our focus today is what small businesses need to know, not only about Connecticut paid leave, but we're also going to give some information about FMLA because Connecticut FMLA underwent some pretty substantial changes at the beginning of this year. And we just want to make sure that you are up to date with those changes and how they may impact your business. So a quick rundown of our agenda. We'll talk about briefly the Connecticut Paid Leave Authority and who we are. We'll talk about FMLA and Connecticut paid leave. Now, I do always preface this presentation by saying they are two different laws, and it's really important to keep that in mind as we're going through, because just because someone applies for and is approved for FMLA does not necessarily mean that they would be eligible for Connecticut paid leave and vice versa. And we'll get into more details about kind of what that means, but just try to keep that in the back of your mind as you're listening to us talk about these different topics. We'll talk about the qualifying reasons for leave. And I will say that the reasons for FMLA and Connecticut paid leave are the same reasons. And that's why it's really hard to talk about one without the other. We'll talk about what you need to know about Connecticut paid leave and then the process of implementing it in your business if you do have an employee that comes and tells you they're putting in a claim. And then we'll go through the same process about FMLA, both what you need to know about the federal and the Connecticut laws, and then implementing that process in your business. And we will leave you with some additional resources at the end where you can get more information as well as different pieces, downloadable pieces that you can share with your employees. And of course, questions. So first, just a quick little introduction to the Connecticut Paid Leave Authority, where Kathy and I work. So it is a quasi-public agency of the state of Connecticut who oversees the paid leave program. And our mission is to provide pathways to accessible paid family and medical leave benefits and to empower employers, administrators, healthcare providers, business owners, pretty much anyone who's impacted by the Connecticut paid leave law and give them the tools they need to help navigate through the program. Just a couple of key dates that led us to where we are today. On January 1st of last year, employers were to begin taking contributions through payroll deduction from employees. It's 1/2 of 1%. And those contributions are to be remitted quarterly to the Connecticut Paid Leave Authority through our electronic payment system. There is a 30-day grace period. So for example, first quarter of 2022 contributions will be due no later than April 30th. And on January 1st of this year, benefits became payable for qualifying events for eligible employees who are applying for the benefit. So let's talk a little bit about FMLA and Connecticut paid leave and how they work together. So FMLA is, I'm just going to minimize, there we go. All your faces were covering up some of my words. FMLA, you may be familiar with, it stands for the Family and Medical Leave Act. And the whole purpose of FMLA is to provide job protected leave when a worker needs to take time away for certain qualifying family and health conditions. There's a federal law and a state law. Both have been around since the 1990s. And the important part of FMLA is that the leave provides job protection, but it's unpaid leave. So some employers do adopt policies to provide for income replacement while employees are on leave. For example, an employer might provide a certain number of weeks of paid maternity leave. They may permit or require their employees to use any accrued PTO while they're out on leave in order to have income replacement. But that's not a requirement of the law. It's just something that some employers opt to do. As I mentioned, and we'll get into the specific details of the changes, but the Connecticut law changed pretty substantially on January 1st of this year, and now applies to almost all businesses in the state of Connecticut. Now, Connecticut paid leave, and the way I like to think of it is it's kind of the flip side of the coin. So where you have FMLA providing job protection, Connecticut paid leave does not provide job protection, but it does provide income replacement for those same qualifying family and health reasons that someone might apply for FMLA. So while someone is not necessarily eligible for FMLA, if they receive Connecticut paid leave or vice versa, most often the reason that they're applying for leave would also be a qualifying reason under Connecticut paid leave for benefits. So the Connecticut Paid Leave Act created a source of income replacement benefits. But again, and I don't mean to sound like a broken record, but it does not provide the job protection piece. You may also sometimes hear Connecticut paid leave referred to as PFML. And if we say that, we're talking about the same thing, the paid portion of it. Let's look at the qualifying reasons. And these are the reasons either for job protected leave under Connecticut FMLA or income replacement under Connecticut paid leave. First reason is medical leave. That's leave that a worker takes for their own serious health condition. And serving as an organ or bone marrow donor does qualify as a serious health condition, as does pregnancy. There is a legal definition of what constitutes a serious health condition, and we'll go through the criteria for that as well, so you have a better idea of what might qualify for medical leave. The second type of leave is bonding leave, and that's leave that a worker can take to bond with a new child that's entered their home through birth, adoption, or foster care. It is applicable for both mothers and fathers, and bonding leave can be taken at any time during the 12 months immediately following the birth or the child's placement in the home. In the case of adoption and foster care, bonding leave can also be used to attend to pre-placement activities as needed. The third type of leave is caregiver leave, and that's leave that a worker would take to care for a family member who's experiencing a serious health condition. The next two types of leave are specific to the military. So we have military caregiver leave, which is leave that a worker would take to care for a family member who was injured during federal active duty in the military. And then we have what's called qualifying exigency leave. This is leave that a worker could take if their spouse, parent, or child was on federal active duty or notified of an impending call to federal active duty. So an example of when this might apply, if you had a worker whose spouse was an active military member who had been notified of an impending deployment, and the military member was the one who primarily provided childcare for the couple's children. The worker could apply for qualifying exigency leave in order to make alternative arrangements for childcare once the spouse was deployed. That's one example of when qualifying exigency leave might come into play. And then the last type of leave is unique to Connecticut. It's the Family Violence Leave Act. And that allows an employee who is experiencing family violence to take up to 12 days in a calendar year of job protected leave and or receive Connecticut paid leave income replacement for the reasons of seeking medical or psychological care or counseling, obtaining victim services from a victim services organization, relocating, or participating in court proceedings related to the family violence. So you heard me say serious health condition several times, and in the statute, there is a definition of what constitutes a serious health condition. So in order for something to be considered a serious health condition, it has to meet one or more of the criteria that I'm going to run through right now. The first criteria would be that due to the condition, the person is required to have an overnight stay in a hospital or another medical care facility. The second criteria would be that the condition results in incapacity of more than 3 consecutive days, and that during that time, the individual seeks treatment from a healthcare provider, and it requires continuing treatment, so perhaps prescription medication under the care of the healthcare provider, and requires the individual to return for a follow-up visit within a month. The third criteria would be that there's a period of incapacity due to a chronic serious health condition that the individual obtains treatment from a healthcare provider at least twice per year. The next would be a permanent or long-term condition for which treatment is no longer effective. So examples of this might be Alzheimer's disease or the terminal stages of cancer. The next criteria would be a restorative surgery after an accident or injury, where if the employee did not have that surgery, it would result in a period of incapacity of more than 3 days. So for example, broken leg, they need to have surgery. And if they did not do so, they would be incapacitated for more than 3 days. And then lastly, as you heard me mention, pregnancy and prenatal appointments do qualify as a serious health condition under that. And I also mentioned at the beginning, serving as an organ or a bone marrow donor also constitutes a serious health condition. Now, understandably, we've been getting a lot of inquiries about COVID and if COVID would qualify someone to receive Connecticut paid leave benefits. And the answer is that simply being exposed to or diagnosed with COVID is not necessarily considered a serious health condition under the law. However, if the worker, and in all circumstances, the worker would need to provide a medical certification from a healthcare provider. So if they can produce that medical certification that shows that having COVID has resulted in one or more of the conditions of a serious health condition, then they would be potentially able to receive benefits. So I'll give you my own personal example. I had COVID a little while back, and I wasn't feeling great. I was sleeping a lot. I was, using over-the-counter medications, things like that, but it did not raise the level of a serious health condition because I did not see a healthcare provider, and it didn't result in these bullet points that you see: overnight stay in a hospital, incapacitation for more than 3 consecutive days with ongoing medical treatment, or exacerbating a chronic condition. So a lot of the inquiries we're getting are for people who are saying, well, I was exposed to COVID and now I can't go to work for 5 days because my employer won't let me come in. So something like that is not a reason that someone can receive paid leave benefits. Now, when we talked about caregiver leave, you heard me say that that's leave an employee might take for a family member who's experiencing a serious health condition. So who qualifies as a family member? Well, there's a different definition under federal FMLA and under the Connecticut laws, both FMLA and Connecticut paid leave. So when we're talking about federal FMLA, an employee can only take leave to care for a parent, spouse, or a child who's under 18 or a child over 18 if they have a disability. Those are the only familial relationships that are recognized for caregiver leave. Now, under the Connecticut laws, both Connecticut FMLA and Connecticut paid leave, the relationships that an employee can take leave and receive benefits for include a parent, a spouse, a child of any age, a sibling, a grandparent, a grandchild, or an individual related to the employee by blood or affinity. What does that mean, related by affinity? It essentially means that if the worker has a significant personal bond with the person for whom they would like to take leave to care for, if that relationship is like one of the family relationships listed, regardless of if there's a biological or legal relationship, they would be able to take caregiver leave for that person. So it's obviously situation specific. It depends upon the individuals involved, but some examples just to kind of illustrate for you what this might look like. If, for example, you have an aunt or an uncle who relies on the employee for unpaid care and their relationship is more commonly what you would see between a parent and a child, that might qualify for a relationship by affinity. A more common example might be an unmarried couple who share a spouse-like relationship. So they share a home, maybe they have kids together, they share finances, but they're not legally married. So that would also be considered relationship by affinity. Now, what do you need to know about Connecticut paid leave? Well, first and foremost, you need to know if you're considered a covered employer under Connecticut paid leave. So almost all employers who have one or more people working in the state are covered under this program. Non-unionized employees of the state of Connecticut are also covered. There are some exclusions. So these categories are excluded from the Connecticut paid leave program. That includes the federal government, municipalities, and local or regional boards of education, with the caveat that if their unionized employees collectively bargain for participation, then all of their employees would be covered. Non-public elementary and secondary schools are also excluded, as are railroads, the governments of other states, and sovereign nations. Now, for sole proprietors and independent contractors, they are not required by law to opt in to participate in the program. So if you pay self-employment taxes, then you're not an employee and you do not have to participate. However, if you would like to participate, you can opt into the program. If you enroll, you do have to stay in the program for at least 3 years, and you would contribute at the same rate as all other employees, so half of 1% of your self-employment earnings. A note to this is if you're a sole proprietor, but you also have employees, even if you choose not to opt in for yourself, you do have to register your business and deduct those contributions for your employees and remit them to the paid leave authority. If you do receive a W-2, then you are considered an employee, regardless of if you're the owner or an officer of the company. The next thing that you need to look at is what makes your workers eligible for Connecticut paid leave. So there's 2 different criteria for eligibility. The first is a minimum earnings criteria. So for a worker to be eligible for Connecticut paid leave, they must have earned at least $2,325 in the highest earning quarter of the first 4 of the 5 most recently completed quarters. That can come from one or more covered employers in Connecticut. So if you have a part-time employee, as long as their earnings between your company and any other covered employers they work for totals that $2,325, they would meet that requirement. And then the chart that you see there, which just sort of visualizes what quarters we're looking at to make this determination. So for claims that are being made in the first quarter of 2022, we're looking back at the quarters that you see in green. So fourth quarter of 2020, and then quarters 1, 2, and 3 of 2021. So if during those quarters that you see in green, the employee has earned at least $2,325 in one of them, then they would meet this minimum earnings requirement. The second criteria is that they're either currently employed in Connecticut by a covered employer, or if they're not employed, that they were within the 12 weeks immediately preceding their claim for benefits. And of course, if it's a sole proprietor, they must have opted into the program. Now we're sharing this information for you for awareness, but you are not responsible for making the determination about eligibility. We at the Connecticut Paid Leave Authority, along with our third-party claims administrator, AFLAC, will look at the information and determine if the employee is covered based on these criteria. The next thing that you would want to know is what benefits will employees actually receive. So workers who earn minimum wage would receive 95% of their base weekly earnings. If they earn more than minimum wage, I'm not going to go through the calculation because it's very, very complicated. But the important thing to know is that benefits are capped at 60 times the minimum wage. So currently that works out to $780 per week, and it will increase when minimum wage increases. An eligible worker can receive up to 12 weeks of income replacement during a 12-month period for almost all of the leave reasons that we talked about. Couple of exceptions are that only 12 days of the 12 weeks can be used for family violence leave. So it's not 12 days in addition to the 12 weeks, it's 12 days of the 12 weeks. And then it's possible for an employee to receive an extra 2 weeks for a serious health condition resulting in incapacitation during pregnancy. Now, if you have employees who come to you and ask how much they can expect to receive from Connecticut paid leave benefits, we do have a tool on our website called the Benefits Estimator, and it's really helpful and easy to use. The employee would just go in and select their pay period frequency, their earnings, and the intended first date of leave. And then when they click estimate, they would see an estimation of what they could expect to receive based on the formula that's used to calculate benefits. Of course, in many cases, employers do provide some form of paid time off. And so let's take a look at how Connecticut paid leave benefits would integrate with any employer provided benefits. Now you see highlighted in yellow there over on the left. This is really important to note. One of the changes to Connecticut FMLA that went into effect in January are that employers are no longer allowed to compel employees to use all of their PTO in order to have income replacement. They have to allow them to keep up to 2 weeks of PTO for future use now. So if an employee is going to be out for 4 weeks and they have 4 weeks of PTO, but they say they want to be able to save 2 of those weeks for something else that's happening later on in the year. For example, maybe their child is getting married and they know that they're going to need to take some time off for that. You can no longer compel them to use all 4 weeks. You can require them to use 2 of the weeks, but you have to let them hold on to the other 2 weeks. So just keep that in mind as we're going through these different scenarios. So in scenario 1, let's say our worker has no PTO to use for FMLA. So either they don't have any PTO at all, or they only have 2 weeks and they choose not to use it. In that case, the worker would be eligible for the full amount of the Connecticut paid leave benefit for the full period of their leave because they're not getting anything from the employer. In scenario number 2, let's say the worker has enough PTO either with being able to retain 2 weeks or they choose to use those 2 weeks, and their PTO will be equal in pay to their regular pay for the full duration of their leave. In that case, since they're fully compensated by the employer, they do not receive any Connecticut paid leave benefits. They do still have that 12-week allotment to use at a later time in the year if it becomes necessary. Those are pretty straightforward, those 2 different scenarios. Now, if we have a worker who has PTO that's equal to their regular pay for part of the time they're going to be out on leave, in that instance, the Connecticut paid leave benefits would start after the worker stopped receiving PTO benefits from their employer. And then in the last scenario, if the worker had PTO that was less than their regular pay, they could receive both the Connecticut paid leave benefits and the employer provided benefits from the first day of their leave, but the combined benefits could not exceed more than 100% of their normal wages. And with that, I'm going to turn it over to Kathy, and she's going to talk about implementing the Connecticut Paid Leave Act.
Hi, good afternoon, everyone, and welcome. Implementing the Connecticut Paid Leave Act. Responsibilities. Workers are contributing 0.5% of their FICA wages up to the Social Security contribution limit. Employers, this happened for 1/1/21. Employers created an account at connecticutpaidleave.org. They deducted the 0.5% from the employee's wages to the Social Security contribution limit, and then they remitted the contribution amount to CTPL with the required backup information. The Connecticut Paid Leave Authority then received and then reconciled the contributions, processed any under or overpayments, and imposed penalties for noncompliance. The Connecticut Department of Labor determines whether they allow employers to take catch-up contributions. For instance, let's say a company didn't start 1/1/21 with their contributions of 0.5%. It's up to the Connecticut Department of Labor to determine whether they're going to allow employers to make any kind of catch-up plan. And this is based on general wage and hour authority.
And just to interject quickly, right now, the Department of Labor did authorize that between now and March 31st, employers can take an additional 1% above and beyond the 0.5% for that catch-up period, but that ends on March 31st. And then anyone who wanted to take any additional catch-up contribution would need to get special permission from DOL.
Responsibilities for Connecticut paid leave claims. So the worker that's going out on the leave must notify their employer about the Connecticut paid leave claim. They need to let their employer know that they're going out on leave and that they're filing for Connecticut paid leave benefits. And the reason for that, we'll see in the next section, is because of coordination of benefits. So the worker submits the application in a timely fashion. They go through the ConnecticutPaidLeave.org site, or they can call AFLAC at 877-499-8606. Now there's a two-step process. The worker goes to the Connecticut Paid Leave site to register and set up an account. And once that account is set up, then they get a pop-up asking them, do you want to file a claim now? And if they answer yes and they go into that portal, that is the AFLAC portal. So it's a two-step process. They provide the supporting documentation for their leave. They update their account with absence information and other information about sources of income. As part of that process, the worker receives what is called an employment verification form. This form they give to their employer, who completes the form and then submits it to AFLAC either through email or through fax. The employer notifies the worker about their PTO policies, including any short-term disability policies. And employers are encouraged to refrain from discriminating or retaliating against workers for filing a Connecticut paid leave claim. The Connecticut Paid Leave Authority works with AFLAC to determine eligibility. AFLAC reviews the supporting documentation, and they approve or deny claims as appropriate. If someone's claim is denied, perhaps they didn't provide the proper medical certification or requirements to file a claim, there is a process called reconsideration. So if someone's claim is denied, we do have a process in place where they can have the claim reconsidered. AFLAC calculates and pays the benefits. They monitor ongoing claims, investigate potential fraud, and impose penalties as appropriate. There is also an appeals process under Connecticut Department of Labor that relates to the denial of claims and to any penalties. So what do I need to know about FMLA, Family Medical Leave Act? FMLA refers to the laws that provide eligible employees with the right to take job-protected leave for certain qualifying family and health reasons. There is a federal FMLA and a Connecticut FMLA. The Connecticut FMLA changed significantly as of 1/1/22. So am I covered under FMLA? Employers who have 50 or more employees within a 75-mile radius, governmental entities of any size, including the federal government, state agencies, towns, schools, railroads, governments of other states are covered under federal FMLA. Covered under Connecticut FMLA, almost all employers who have one or more people working in the state of Connecticut. And for the state of Connecticut, all state employees are covered under CTPL. Who is not covered under Connecticut FMLA? That would be the federal government, municipalities, local or regional boards of ed, non-public elementary or secondary schools, railroads, governments of other states, and other sovereign nations. Is my employee eligible for leave under FMLA? The employee must have been employed by your company for at least 12 months and worked at least 1,250 hours in the 12 months preceding the leave. So that's a requirement for federal FMLA. Under Connecticut FMLA, they have to have been employed by your company for at least 3 months immediately preceding the leave, and there are no hours worked requirement. So how long is the job protected leave? Under FMLA, an employee can receive 12 weeks of leave in a 12-month period for all FMLA reasons, except up to 26 weeks of leave in a 12-month period for military caregiver leave. Now, I know this sounds like a lot of information. We're talking about federal FMLA, Connecticut FMLA, and we just talked about Connecticut paid leave. The good news is that everyone's going to receive a copy of this PowerPoint as a reference material. The Connecticut FMLA, up to 12 weeks of leave and a 12-month period for all FMLA reasons, except there's 26 weeks of leave and a 12-month period for military caregiver leave. An employee may also receive an additional 2 weeks of CTPL benefits for a serious health condition resulting in incapacitation during pregnancy. Connecticut Family Violence Leave Act, that's under CTPL. It can get up to 12 days in a calendar year. So how did Connecticut FMLA change? The old Connecticut FMLA, which is through 12/31/21, applies to employers with 75 or more employees. Employees must have worked at least 12 months for the employer with at least 1,000 hours during the 12 months prior to the time that they're taking FMLA leave. The employee has job protection after 12 months. Employer can require employees to use all accrued time for paid time off. So that could be sick time, vacation time, PTO time. So as of 1/1/22, CTFMLA applies to employers with 1 or more employees. There is no hours worked requirement, and after 3 months of employment, there is job protection. Up to 12 weeks and a 12-month period for all leave reasons. Again, except 26 weeks of leave is available for military caregiver leave. And an additional 2 weeks may be available for incapacitation during pregnancy. The employer can require employees to use all their accrued time off. However, effective 1/1/22, employers must allow their employee to keep separate up to 2 weeks of accrued PTO. So for example, if someone has 4 weeks of vacation time, they use 2 weeks for their leave, and then they keep 2 weeks for, however else they want to use it during the year. So implementing family medical leave, FMLA. FMLA claims. The worker notifies the employer they need to take time away from work. They submit an application, provide the employer with supporting documentation. So you'll notice this is different from Connecticut paid leave. CTPL, employees go to AFLAC. For FMLA and Connecticut FMLA, the employees go to the employer. So the employee provides the employer with supporting documentation, and the worker must comply with the employer attendance and call-in policies. The employer should have established leave policies, including rules about taking paid time off, process leave requests, monitor the leave usage, and then manage the worker coming back to work. Connecticut Paid Leave Authority has no official responsibilities related to Connecticut FMLA, but we provide information as part of this training. So the Connecticut Department of Labor regulates, is responsible for regulations concerning Connecticut FMLA. They provide guidance to workers and employers about Connecticut FMLA. And here is the website if you needed additional guidance or information about Connecticut FMLA. The Federal Department of Labor is responsible for the regulations on the FMLA. They provide guidance to workers and employers about federal FMLA. And here is their website if you need more information. And they do investigate complaints regarding denial of claims or discrimination and retaliation. So the job protected leave process. FMLA and Connecticut FMLA offer job protection. Connecticut paid leave does not offer job protection. It offers income replacement. So that's something to keep in mind. It's a major difference between the different types of leaves. The worker notifies the employer that they need to take time off. They don't necessarily have to use the term FMLA because sometimes employees or workers don't know about FMLA or they just don't want to use that term for whatever reason. Ideally, they give 30 days in advance notice for the leave if it's foreseeable. And if it's an emergency, as soon as practical, they need to notify their employer that they'll be out. Again, applying for Connecticut paid leave benefits is not the same as applying for family medical leave. So the employer determines if the worker is eligible for Connecticut FMLA and notifies the worker if they need to provide any additional documents. The employer is responsible to notify the worker if they're eligible, and they have 5 business days to do so if they're eligible for Connecticut FMLA. There is a document called Notice of Rights and Responsibilities, which the employer is responsible to give to the employee when they are filing for Connecticut FMLA, and that you could find on the website. This is not the leave approval process. Oops. We lost our presentation for a second. Okay. Job protected leave process continued. The worker provides the required documentation to the employer to support the reason why they're going out on the leave. They have 15 days to give the documents to their employer. If the worker is trouble getting the documents, sometimes if they need to get a medical certification from their physician, and let's say the physician is, I don't know, out on vacation for 3 weeks, the worker needs to let the employer know and give them a reasonable extension of time. The employer reviews the documents and notifies the worker if the leave is approved under Connecticut FMLA and or federal FMLA. Again, the employer has 5 business days once it's received all the required documentation to notify the worker of the decision. If there is any policy with the employer that the employee must use PTO, they should be, notified by the employer. A policy in place when and how to call in. For example, do they call their manager, their supervisor, the owner, whoever it is, establish the policy and then communicate it to the employee as to what are the policies and procedures for calling in, and if a fitness for duty is required. A worker reports to the employer when they actually take the leave. When calling out, the worker should say, "This is my FMLA leave." It is the employer's responsibility to track the leave against the FMLA balance. So for example, let's say someone got approved for 10 weeks. It's the employer's responsibility to track week to week how much time that employee is taking against the approved 10-week period. The employer returns the worker to the job they had before they went on the leave. The worker has the right to the same job with the same terms and conditions. If the worker was out for their own serious medical condition and they have some medical restrictions, the employer must consider if there are any reasonable accommodations they can put in place so the worker can perform the essential functions of their job. So other laws to consider. Laws providing job protected leave. We have the federal FMLA that applies to employers with 50 or more employees. Connecticut FMLA before 1/1/22, so actually through 12/31/21, Connecticut FMLA applied to all employers with 75 or more employees. Effective 1/1/22, the law was changed and it applies to employers with 1 or more employees. Workers' comp is for on-the-job injuries or illnesses. Americans with Disability Act, 15 or more employees. Pregnancy Disability Act, 15 or more employees. The Connecticut Fair Employment Practice Act, 3 or more employees. Laws providing income replacement during leave. Connecticut paid leave effective 1/1/22 if you have 1 or more employees working in the state of Connecticut That's effective 1/1/22 as to income replacement. It's not job protection. And then we also have workers' compensation for on-the-job injuries or illnesses.
Thank you so much, Kathy. So we just want to leave you with some additional resources before we get to your questions. Our website is a great source of information. So the different documents that you see here can all be found on our website, and they're downloadable. So we have an employer toolkit and a human resources toolkit that go into more detail about the topics Kathy and I just talked about. We also have several pieces that you can provide to your employees. So we have an employee rights poster, a rack card, a paycheck insert, and a fact sheet. Some other areas, you see the link, the address to our website, ctpaidleave.org. On there, we have several hundred frequently asked questions. That's also where you can find the benefits estimator that we showed an example of. If you do have more questions, we do not have a call center, so there's no phone number that you can call us at, but we do have a contact us portal that you can access through our website. So what you would do is go in there and enter your information. If you do prefer to speak to someone, we can certainly accommodate that. You would just give us your best contact phone number, and then one of our contact center representatives would call you and help you work through your question or concern. And then again, any questions about Connecticut FMLA really do fall under the supervision of the Connecticut Department of Labor. And that web address again, you see there the portal.ct.gov/DOLUI/new FMLA guidance. That's where you can find the appropriate posters, the different forms that you might need, medical certifications, etc. And any questions about FMLA would be directed to the Department of Labor. So again, with Connecticut paid leave, employees are coming directly to us at the authority, and we work through that process with them. All you on the employer side have to do is fill out that employment verification form for us. On the FMLA side, that job protected piece is really between you as the employer and your employee. So we at Connecticut paid leave don't have anything to do with approving FMLA or giving guidance on FMLA. We're really just the payment piece of it if someone is eligible for income replacement benefits. And so with that, that concludes our presentation. So Kathy and I are happy to answer any questions that you might have. I see Elizabeth had put some different links in the chat. Thank you so much for that, Elizabeth.
And to unmute, you can just simply click the unmute button on your screen, or if you do Alt-A on your keyboard, and of course, if you're using your phone, you can just tap, I believe you can tap unmute on your phone, or it's star, one second, I'm blanking. But don't be shy.
I have a question regarding where does short-term disability fall into play with this?
It's a very good question. It's actually a coordination of benefits. I would suggest reviewing your short-term disability policy to see if it is primary or secondary with any state leave benefit plan. There are short-term disabilities policies that are written where they're primary or they're secondary. So I would check with the short-term disability plan document and look at the coordination of benefits and then apply the benefit according to that document.
Someone might have said, but I didn't pick up on it. For a typical worker, what is the percentage of the pay that they would receive on the CTPL plan?
Percentage.
So if they make $500 a week, will they get the full $500 a week from the plan?
I can address that, Kathy.
Sure.
So
Thanks.
it's actually, there's a formula, right? So if the person earns minimum wage, it's 95% of their base weekly earnings. So in that instance, if it were 40 hours a week at $13 an hour, that works out to $520 a week that they're earning. And so in that case, they would receive 95%, which works out to $494 per week. If they make above minimum wage, that's where it becomes a little bit, it's a complicated formula because they receive 95% of the 520, and then they receive 20% of the difference between that 520 and whatever they make. So that's why we don't go through actually explaining it, because it's just a whole lot of math and it's not anything that we would expect you to calculate. But that's where the benefits estimator can be really helpful. If somebody says, hey, I make $750 a week and I want to see what I might be eligible for.
I understood. And actually, the reason for that question was really related to the first question. So if the short-term disability plan that the employee has covers 100% of his pay, what happens?
Then they don't,
They would not be eligible for
Right, they
Connecticut
wouldn't.
paid leave because the combination of any benefits cannot exceed 100%.
Okay, that answers the
Yeah.
question. Thank you.
You're welcome.
And for those that are on the phone, it's *6 to unmute yourself. Of course, if you're on your computer or on the app on your phone, you can just click unmute, or you can type Alt-A on your keyboard.
Hi, I have a question on the Connecticut leave. We received and replied to the AFLEC form.
Okay.
Is there a way for us to find out through the system how many weeks the employee has requested to be out?
I can take that one, Jessica. Once an employee is approved or denied for their Connecticut paid leave application, the employer will receive an email regarding the approval or denial. So on the employment verification form, there's a section that asks for your contact email. And you can also request a letter by US Postal Service, but the email is the best because it's the quickest way, and you'll know sooner than waiting for a letter in the mail. But the email that you'll receive contains the name of the employee, the type of leave, the start and stop date of the leave, and the weekly approved benefit amount. So it's important to put the email contact. We're not going to be emailing you all kinds of questions, but it's just a way, once the claim is approved or denied, it's a way to communicate with the employer to say, yes, you know, Mr. Smith or Mary Jones is going out on leave, and here are the dates.
Okay, I don't believe I received that email. So is there a second opportunity for me to contact AFLAC?
Sure, if you give me, if you can put in the, well, if you can give me your name, your contact information, Jessica, what's the best way for them to, I can check with AFLAC and then do a reach out. Make sure we have the right information on file.
Yep, I'll put my email and I'll put my email on the chat. And if you want to just contact me directly, I'll share that with Kathy and we can find out. I do want to address that at the beginning of January, we did discover that AFLAC was not sending out those notifications. That has since been corrected. So
this was the beginning of January.
Yeah, so they are retroactively going through and sending those emails. But like Kathy said, we can look into it for you and let you know if they were in fact approved and what the start and end dates were, et cetera. So I'm just going to put my email address in the chat, and you can feel free to just send me your contact and I'll connect you with Kathy and we can take it from there. Just to reiterate, that has been corrected. So moving forward, anyone who has someone going out will get that notification of approval or denial.
Thanks, Jessica.
No problem. I would put your email, Kathy, but I'd probably spell your last name wrong.
I know, that then would be the wrong email address, so.
There was, I think, a question in the chat. Is there a simple document or checklist for employers to use that, you know, they could just go through to make sure that they're in compliance? Is that on the website anywhere?
So I would say the best place to look for that in the HR toolkit, when we create, Kathy and I worked really closely on creating the HR toolkit, and we really wrote it so that it would be useful both for people who have like a full-blown HR department, but also for the small business owner that is their own HR department. So that would be my first suggestion, would be to look in there, because we do have kind of like a flow chart and checklists and things like that. So that can be, if you go onto our website, right at the top, it says, oh, and thank you, Elizabeth, the link, she put the link in the chat. But if you go on the For Employers tab, that's where all those downloadable resources can be found.
Hey, Jessica, I think we need to hire Elizabeth. She knows a lot.
Well, and I will say for NFIB members that are here today, when we follow up with you after this, I'll be sure to include some of these links as well. Are there other questions? You can just unmute yourself. If you're on your computer, you can also do Alt-A, or if you are on a phone, you can do *6.
And we also will be providing a link to the recording as well, if you'd like to rewatch it. I'll also say that on our YouTube page, we put any public webinars that we do, because we do webinars all the time for just anyone in the general public who would like to attend. Though all those recorded webinars are there too. So we tend to cover a lot of the same information every time. So if you wanted to go and watch any of those as well, those are accessible.
Well, I know we have about 10 minutes until the top of the hour. So if anyone has any other questions, please feel free to, like I said, unmute or let Andy or myself know, and we can connect with Kathy and Jessica as well. But with that, I mean, I'll just say, thank you, Jessica. Thank you, Kathy, for joining us today. We certainly hope that this is the first of probably several opportunities to work with you. And so we look forward to future conversations and presentations. And of course, thanks to NFIB members for joining today. Please reach out to myself or Andy Markowski anytime if you have questions. And we hope that this was helpful for everyone.
Thank you, Elizabeth. Thanks for having us. And I guess we'll just close by saying we know that this is new. There's a lot of information. We know that you're juggling it along with running your business. And, I happen to be married to a small business owner, so I see firsthand all the different things that you have to consider every single day. So we know it's not easy. We really thank you for taking the time to join us, and we are definitely here to help. And please reach out with any other questions.
All right, good deal. Well, thanks everyone for your time, and we'll be in touch.
All right. Thank you,
Thanks,
everyone.
Bye-bye.
Bye.